Each legal shorthand 100 words per minute. Ready, start. I hereby direct High Court Legal Services Committee to appoint Mr. Patak, learned advocate, to appear in the present case to assist the court to decide the aforesaid question of representation by advocate in reference proceedings. High Court Legal Services Committee shall give the appointment letter to him to that effect. Mr. Patak, in his opening remark, informs the court that the present issue has been decided by various high courts, including this court also, and according to his opinion, the core issue is now pending in the Supreme Court. He would submit that, depending upon the exigency of the case, there are arguments and cross arguments made whereby courts have either allowed appointment of advocate to represent the parties in the proceedings or denied in some cases. He would submit that challenge before the Supreme Court, inter alia, pertains to the provisions of Section 36 (4) of the Industrial Disputes Act, 1947. He would submit that, coupled with the said provisions, Section 30 of the Advocates Act has also been invoked. A copy of the CRA is directed to be given to Mr. Patak forthwith. Mr. More, in presence of court, has handed over copy of CRA to Mr. Patak. He shall prepare his submissions and accordingly file the same to assist the court in the aforesaid case. Stand over to 29th September 2025 under the caption for directions. Briefly stated, respondent number 1, employee, was engaged as a temporary worker in applicant's laundry. It is applicant's case that respondent number 1, employee, abruptly left the job without prior intimation or notice to applicant. Thereafter, respondent number 1 filed application before the Labour Commissioner seeking reinstatement and continuity in service along with back wages. Applicant appeared through his advocate and filed reply therein. However, owing to non-prosecution by respondent number 1, employee, Labour Commissioner passed order of closure of proceedings. Subsequently, applicant received summons to appear before the 7th Labour Court at Bandra. Applicant approached the court through his advocate and was informed that respondent number 1, employee, filed application under Section 36 of the Industrial Disputes Act 1947 for short ID Act seeking to restrain applicant from being represented by advocate. Consequently, applicant filed his written statement drafted by his advocate but filed by his representative. Thereafter, respondent number 1, employee, filed his evidence along with documents whereupon the Labour Court directed applicant to commence cross-examination. Applicant, being a person with limited expertise in the field of law, filed application seeking permission for appointment of advocate to conduct cross-examination and complete the trial. Stop. By order dated 1/12/2023, Labour Court rejected the said application. Stop. Hence, the present civil revision application. Stop.